suppose you're right as to all of those things, that there was essentially no control from the city government here, and that pushes strongly in the direction of, well, it's not government speech if government doesn't control it. But suppose, on the other hand, one thinks that reasonable observers would think that this was government speech. And there might be some arguments about that, but I just want to assume it for the moment. Suppose one goes in one direction and the other goes in the other direction. How do we think about that?
Well, I think first, a reasonable observer ought to be charged with knowledge of the basic contours of the program we're talking about. This court's cases dealing with forums, going back to Widmar and Rosenberger and Lamb's Chapel, some of the others, Cornelius, have said that the right unit of analysis is the program to which the plaintiff seeks access. It can't be at too high a level of generality, so it's the combined federal campaign, not the federal workforce. In Lamb's Chapel, it's use of the schoolrooms after school, not during the school day. And so I think here you would have to assume that the reasonable observer is aware that there is such a thing as a flag-raising program.
Yeah, I mean, Justice Sotomayor called that a fiction. And I think that's an assumption that does verge on a fiction, right? The person walking by City Hall every day does not know about the contours of the flag-raising program. It just knows on Monday through Thursday, I saw the City of Boston flag, and now I see another flag. Surely that's just the City of Boston deciding to fly another flag instead of its own flag.
So I have two related responses to it. First, I think it's just as likely that an observer might know that there exists some kind of flag-raising program, and when they call into Boston to complain about the flag they see on the flagpole, they're not necessarily complaining that Boston is endorsing that flag, but rather they might be complaining that Boston has opened up its flagpole for a use that would permit such a flag to be flown. But more broadly speaking, I think it would be a little bit problematic if we allowed, and I realize I'm speaking on behalf of the United States here, but we take this court's cases to say that the First Amendment should not allow a government to evade the strictures of the First Amendment and the prohibition on viewpoint discrimination simply by being innovative in its program, or by fooling the public, or by having a secret program on the side that only a few people know about. The fact is, once the government, or the City of Boston here in particular, is chosen to open up its flagpole for use by third parties, the First Amendment imposes certain restrictions on how it can run that program.
You listed certain factors, I think 3, the 284 approvals,